So as Brian had mentioned, just very briefly, I'm the founder of Bamboo Data Consulting. I'm also a privacy lawyer and consultant. And what I help organizations do is really identify their privacy risks by reviewing what personal information they collect, whether they're allowed to collect that information, how they use it, and who they disclose it to. And I help organizations implement privacy into their processes, services, and products in order to reduce the risk of a privacy breach or a privacy defense, and ultimately build a defensible position, but also, and maybe even more importantly, build the trust of their consumers so that they can gain that competitive advantage in market. So I suggest that we start with Privacy 101. What is privacy in the first place? Privacy, surprising to most, is not about having a secret. It's about having control over your personal information and deciding who gets it, what they get, how the information will be used, and who they can share it with. Now, when we talk about personal information, most people think that personal information is name, address, phone number. But personal information is actually a very broadly defined term. And it's imperative that you understand what personal information is, because you need to be able to understand what you need to protect. So personal data or personal information can certainly include login credentials, travel history, your geolocation, browsing history, online and offline behavior, credit card information, health information, including facial recognition and biometric data, as well as employee information. Now, in general, the private sector companies are collecting more personal information now more than ever, because personal information is considered to be an asset. And especially in the wake of COVID-19, we're seeing that more companies are starting to, of course, become more digital, and they're collecting more personal information. And as they become more digital and develop a digital infrastructure to become efficient, productive, and ultimately survive, my concern, and I think it's a concern of a lot of privacy experts, is that they're going to experience an entirely new crisis once the COVID crisis is over. And they're going to experience the fact that they've collected all this information, personal information, and they don't know what to do with it. So, in the mad rush to survive this crisis, or to get to market, if you are a startup, businesses need to consider privacy and security vulnerabilities as they create their network, and they must really think about the implications that they're getting themselves into. Now, we've all read the headlines and we know that privacy breaches are on the rise, and I think even more so with COVID-19. And we've heard about Equifax and Desjardins, Capital One, Marriott now a second time, and Life Labs. And there's a misconception, as Arani had alluded to before, that small businesses are not affected by breaches because the bad guys are after the big companies with the big bucks. But that's just simply wrong. According to Verizon, who did a study, 43% of breaches involve small businesses. And the reason is because they are simply unprepared, they do not have the proper infrastructure, and they are an easy target. Now, unlike the large enterprises, it is more difficult for the small businesses to recover after a breach. They're facing a financial hit, they're paying ransom, they are paying individuals in class action lawsuits, there are costs related to legal fees, forensic investigation, but even more so, there's reputational harm and the loss of your customers due to a lack of trust. Now, according to our privacy commissioner, 92% of Canadians are concerned about their privacy, so they lack the trust. Now, you may say to me, well, that's fine, but they're still giving us their data. And I will say to you, you're absolutely right. And despite the concern that most consumers have, they're still willing to give up their data. And why is that? It's because they feel that they don't have a choice. You're providing them with something that they want, and the only way to get it is to give up their personal information. So that is the privacy paradox. And this is a big problem in the eyes of regulators and legislators because our privacy legislation is consent-based. And if you're not giving an individual the consent to maybe choose what data they're going to disclose to you, then you're not actually getting meaningful consent. And if you don't have meaningful consent, you really should not be collecting that information in the first place. So what regulators are doing is they're going to be amending our privacy legislation in order to level out the playing field between the companies who are collecting personal information and those individuals who feel that they have to give up their personal information. And what we can expect to see are some significant changes that resemble the GDPR, which is the General Data Protection Regulation. That is a very strict, robust, and prescriptive legislation in the EU with some hefty fines if you're not in compliance with that legislation. So some things that we can see or that we're expecting to see in the amendments to PIPEDA, which is our own federal privacy legislation, is a rights-based or more rights-based provisions, which means that we're giving more control to the individual, control about how they gain access to the information you have about them, control about how they can request to delete their information, or data portability, how they can take their data and port it elsewhere. Another thing we can expect to see is more prescription around how to obtain consent that is meaningful and informed, as well as transparency about how you are using the data that you're collecting, especially around AI. Regulators are expected to have a lot more enforcement power to issue fines and greater fines, as well as companies may be required to demonstrate that they've incorporated privacy by design, which is a concept of embedding privacy directly into your product, your process, or your service from the inception as opposed to an afterthought. Now, as startups or small businesses with a very limited budget, especially in a global crisis, quite frankly, it's impossible for you to comply with all of your privacy obligations at once. And privacy compliance is not a journey, it is a journey. It is not a sprint. And in that regard, I recommend that you take a risk-based approach and address the most high-risk areas first. Now, every company is going to have different high-risk areas, but based on my experience, I have identified 4 high-risk privacy areas that I think affect most businesses that I've assessed and worked with in all sectors. Privacy accountability, data retention, vendor management, and mandatory breach notification. So let's first have a look at privacy accountability. Now, privacy regulators put a very heavy emphasis on accountability, which starts with privacy governance. So who is responsible and accountable for privacy in your company? Unfortunately, small businesses often do not have the budget or the capacity to have a full-time privacy officer, but that doesn't absolve them of their obligation to maintain and oversee privacy in their business. One way to overcome it, and there are multiple ways, but one way is to hire a virtual CPO who will address your privacy concerns as they come up and identify privacy risks for you. You also need a suite of essential privacy policies and controls. Now, this includes having a website privacy policy, a cookies policy, Now more than ever, a work from home policy, retention policies, and a breach management policy. And you must implement those policies. Otherwise, they're just words on a piece of paper and you have not at all reduced your risk. A significant emphasis by the regulators will be around the way in which you seek consent. And I've mentioned this a few times now, and now you understand the importance of seeking consent and the importance of transparency. So having a long privacy policy that is legalese and difficult to understand will not demonstrate to anyone that you've actually obtained meaningful or informed consent. Also be mindful of whether you're using data that you've collected for a secondary purpose and whether you have consent to use it for that new purpose. And lastly, regulators will also look at whether you've instilled a privacy culture, whether there's that tone from the top about privacy, and whether you've provided privacy training and awareness to your staff, because your staff is often the weakest link to a privacy breach. Now, moving on to data retention. Most companies like to retain data indefinitely because they think that they'll need it one day. However, the more data you retain, the greater the implications are to you once you are breached. So a few things to consider. Review the purpose and the use of the data that you've collected. Have you fulfilled that purpose? And if you have, then technically you don't need that data anymore. But you also need to consider legislation and whether there's any prescribed retention periods. And if there are, then you retain that data for that prescribed time. If you decide to retain that data past that prescribed legislative period, then identify what are the risks in retaining that data past that period and measure it against your own company's risk appetite. And then apply appropriate security safeguards, such as reduced access to the data, encryption, maybe securing it in a vault. But ultimately, if you can anonymize that data, then it is no longer personal information, which means that you can retain it for as long as you'd like. Moving on to vendor management. Now, when you hire a vendor, you outsource your data, but not your responsibility over that data. You remain the data custodian. So any misuse of data by a vendor is your liability. Vendor risk management is becoming an increasingly important issue as businesses outsource more of their processes, which used to be managed in-house. So regulators are expecting you to conduct your due diligence on your vendor. When you're entering legal agreements with your vendor, ensure that you limit the way in which they use the personal data, outline how they must return the personal data to you once the relationship terminates, identify the jurisdiction that the data is stored in, and ensure that they notify you as soon as possible if they experience a breach, since it is your responsibility to notify the regulators if there is a breach. Now, on the other hand, as startups, in possibly even as small businesses, you may be a B2B business or company, in which case you're providing services as a vendor. In that case, your clients or your potential clients might conduct due diligence on you. Similar to the way I just described, you must conduct due diligence on vendors. And they're going to want to see your privacy and security program in your posture. And there is a risk that you will lose that client if you cannot demonstrate that you have the proper infrastructure in place. In the last year, over 28 million Canadians were affected by a breach. Other than, of course, having a privacy response plan, you must be aware of your obligations under PIPEDA. If your company experiences a breach that implicates privacy, or rather personal data, and results in a real risk of significant harm to an individual, and that individual could be one or it could be a million individuals, you must report that breach to the privacy regulator. And you must also notify those individuals affected by that breach. Now, regardless of whether you meet that threshold test, even if you don't need to contact the regulators, you must maintain a record of any incident or any breach for 24 months, irrespective of whether you meet that threshold test. So the part of the presentation that most people don't like to talk about, money, okay? You need to create a privacy budget. And it is not just good business, but it is actually good for your business. And that is why it's a great return on your investment. And a study last year showed that 55% of companies who were surveyed increased their privacy budget. By doing so, they were able to mitigate their breaches. They were able to build trust and loyalty with their customers. They were able to build operational efficiency and attract investors and consumers. So, coming to the end of my presentation, here's the list of questions for you. And I propose to leave you off with this. If you answer no to any one of these questions, then I suggest that you think about seeking help with your privacy or taking it on yourself. But you need to implement something to reduce your risk. So, does your privacy policy accurately reflect the ways that you collect, use, and disclose personal data? Do you have someone in your business that can identify privacy risks and address them for you? Do you retain personal data indefinitely? Do you do your due diligence on your vendors and limit their use of personal data? If you are audited by a client, do you feel confident that you will demonstrate privacy compliance? Do you have a detailed plan on what to do if there was a privacy breach? And lastly, do you know when you should report a privacy breach to the regulators and notify affected individuals? So thank you so much for listening today. I'm obviously very passionate about privacy. Please feel free to reach out to me at any time. I love to talk about privacy and would love to speak to you. Thanks, everyone.
All right. Thank you very much,